Welcome back, everybody, to our studies in land law. What we're going to do in this lesson is carry on talking about co-ownership, talking about the issue of severance, talking about the methods of severance, focusing on this idea of mutual agreement. So far, this is the as a point of note, this is the penultimate lesson on the subject of severance. We're talking about the concept of mutual agreement as a method of severance. What we mean by this is essentially the ways in which severance can take place. We know that from previous lessons that we've looked at the first two main methods for which severance takes place. There's acting on your share, which is essentially the process of going from a joint tenancy to a tenancy in common, will essentially involve going from acting as a cohesive group in the co-ownership to acting as joint tenants with separate shares. So if you act in a way that implies that you are a tenancy in common, then this will have the effect of severance. And then you also, of course, have the concept of notice, the idea of providing notice to the other joint tenants that you are going to sever, your intention to sever. The last two main methods of severance are mutual agreement and mutual conduct, with the final one being forfeiture. With the final one being I forget the name. Basically, where you commit the homicide of an individual, you commit homicide of an individual, and that has the effect of severance, owing to the fact that you can't benefit from your own crime. Simply put, the idea of mutual agreement is one that is very easy to understand. As the name suggests, if the parties to the joint tenancy mutually agree to sever, they will be sufficient to establish the severance of the property. Simple as this. There are, of course, a number of conditions attached to this. The conditions for mutual agreement are as follows. In order for the agreement to be mutual, it must be made between all of the beneficial joint tenants of the property. So this really concerns itself with the mutual part of the idea of mutual agreement. It has to be all of the beneficial joint tenants of the property. There's not necessarily any specific requirements as to the format of the agreement, so it could be satisfied through an oral agreement, an oral understanding, a conversation essentially about severance. It could be satisfied through written, some kind of written agreement, some kind of written notice that has been established. Either way would actually suffice, because essentially it is representative of the wills and the wishes of every single joint tenant to the property. If this is in writing, then the writing need not be enforceable, but it does need to be a fixed agreement, not subject to any kind of amendments. This is one of the main requirements for the mutual element of the mutual agreement. And we can illustrate this in the case of Burgess and Rockwell from 1975. In this case, the defendant and the claimant's father had both brought a house, both providing 50% of the asking price each, so half and half essentially. There was a dispute which arose around the promise made by the defendant to sell her shares to the claimant's father. When the claimant's father died, the claimant then took up the dispute. So this was a case involving the claimant and the defendant, of course, but the claimant was essentially the child of the claimant's of the father, who was the original purchaser of the property. The dispute carried on. The father died, and then the dispute carried on under the child when the claimant's father died. The court held that the beneficial joint tenancy had been severed by way of oral agreement. This was an oral agreement which was made between the defendant and the father of the claimant. And so the result here was, by way of mutual agreement between the parties on the joint tenancy, there was a clear indication that there was an intention to sever. There was a clear mutual agreement for the severance of the property, and as such, the property had been severed. It's important that we think about intention to sever, not necessarily requiring any formalization in the process of mutual agreement, i.e. there not needs to be any kind of deed. It doesn't need to be written in a particular way. It could be orally agreed upon, or it could be written down and agreed upon. These are all the sort of the lacking of formalization requirements in the process of mutual agreement. The thing that is required is that there is clearly an intention on the part of the parties who are present to sever, and this has to be shown in either the words or the decisions of the parties. This may be expressed, there could be an expressed intention to sever, which is obviously very, very easy to ascertain and very, very easy to understand, but it could also be an implied intention to sever, a little bit more difficult to ascertain whether or not there was an implication that severance was taking place. It must be an intention to sever, and it must be a common intention to sever. These are the two things that need to be noted. An intention to sever firstly must exist, but this intention to sever must also be common to all of the parties in the joint tenancy. Remember, this is mutual agreement. This is an agreement between the parties to the co-ownership for an intention to sever the property.